Good afternoon, everyone. Allison Skylark here with Consolidated Planning Group. We are so happy that you have joined us today for our webinar. We are going to be talking about the Special Needs Trust, and we are here today partnered with the Weeks Law Firm and Rachel Dickison, not Dickinson, I always like to say, because I know everybody messes that up all the time. So I want to just go over a couple of housekeeping items from the very beginning. First of all, thank you for sending in your questions ahead of time. We did get them, so we're going to go through those questions, as many as we can. If you if you put your question already, if you've already submitted it, we have it. You don't have to put that in the chat box. We're going to get to those questions. We are in webinar mode today, which means that we can't see you or hear you, but we do know that you're here, and we're glad that you're here with us today. If you have a question throughout the presentation, feel free to put that in the chat box. And as I said, we'll get to just as many as we can during the time that we have together. So if you're planning your time, we're going for an hour today. We start on time and we end on time. That is always our goal. And as it relates to taking notes, you can take as many notes as you want, but everyone is going to get an email today with a link to the recording as well as a copy of today's slides. So any kind of special details and stuff like that, you are going to get a copy of the slides. So Consolidated Planning Group, for those of you that are joining for the very first time, again, welcome. For those that have been attending our webinars for years, welcome back. We are a holistic special needs financial planning firm. We have over 30 years of experience. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. We help people plan for the future of their loved one with a disability. I myself am a parent to adult children with disabilities and have navigated these waters myself, and I would say it's not for the faint of heart. I eat, sleep, and breathe this professionally, and I know when my kids were transitioning, I thought, why? Why is everything so hard? There's all these things that we're supposed to know, what we're supposed to do, say, not say, apply for, not apply for, and it's also very confusing. So these webinars were born out of my own frustration of the difficulties that we all face as, whether a professional serving individuals with disabilities or a parent or a loved one that has a disability. So the webinars are really designed to empower you, to give you the tools and resources that you need to make important decisions as it relates to your loved one, to preserve eligibility for state and federally funded benefits. We'll talk about that a little bit today, and to know kind of some of the steps that you need to take. There's all these things that we have to know, and it all generally ties back to staying Medicaid eligible. That's a lot of it, right? So today we're talking about a special needs trust, the different types of special needs trust. And a special needs trust is a place that you can have money outside of the Medicaid limits. For the state of Texas, those limits are $2,000 in the person with the disability's name. You can have money above and beyond in a special needs trust. And of course, there's ABLE accounts as well. All of our webinars live on our Consolidated Planning Group YouTube channel, which you can subscribe to for free. There are about 600 webinars out there, and we have tried to label them intelligently so you can select the one that might be for the step that you're on in the planning journey. We help people put protection plans in place. We do a lot of lifetime care planning, transition planning. We help set up ABLE accounts, and we do a lot of advocacy by way of our webinars. Now, fewer than 0.1% of all financial advisors in the U.S. focus on special needs, and I would argue that those are probably similar numbers as it relates to attorneys that are specifically nuanced and working with individuals with disabilities. So what we suggest is that when it comes to planning for special needs, know who are the right people that you should have on your bus when it comes to planning. We don't do what the estate planning attorneys do. We don't create guardianship documents. We don't create trust. We refer out to people like Rachel for these services, and they don't do what we do. We're the money. How much money do I need to fund that special needs trust? How do I make sure that I have money in the right buckets to preserve eligibility for state and federally funded programs? When and how should I apply for those types of programs? how do I retire and stay retired for 25 to 35 years and still have enough money to fund that special needs trust? And a lot of families have more than one child with a disability. So we always like to kind of draw the lines of what they do versus what we do, because they get a lot of calls for what we do and we get a lot of calls for what they do. But the truth is that we work very closely together, but you need both of us when it comes to planning. And what we found is, while there are a lot of financial advisors in the US, there's a lot of attorneys in the US. We find that our situation is specialized, and it's really important that you work with a specialist that is nuanced with regarding people with disabilities. When you don't, and you might say, well, I don't think I did. What my advice is don't beat yourself up on that. So if you've done any planning at all, great. But it might be important for you to have your documents evaluated, or kind of get a second opinion on your documents to make sure that they have the important components to them that they need to from a special needs perspective. And so same thing with financial advisors. Financial advisors, there's many, many, many in the US. Very few, work with special needs. And what can happen, and what we see happen, is accidentally having money in the wrong buckets, disqualifying a person for state or federally funded programs. We see improper beneficiary designations, leaving money to a special needs individual directly, as opposed to indirectly to the benefit of said child through a special needs trust. So that's why it's so critically important. So whether you work with us or Rachel or someone else, do really try to focus on working with a professional that is nuanced in special needs. One of the questions that came in today is, I want to know who to contact in Chicago. From a financial planning perspective, we work with people all across the United States, not just in Texas. But when it comes to attorneys in your area, so whether you're in Illinois or any other state, one way to find a qualified attorney is looking at the National Association of Elder Law Attorneys. That is one good place. You can put in your zip code. I also, as a parent of kids with disabilities, I have found that places like the ARC or other special needs community, like 501c3 organizations, have a number of referrals that they've worked with in the past that they know are great. And then also there's a lot of Facebook parent groups for people with disabilities, and usually the rising stars rise to the top if you post that question out there. Another place that you can look to find a professional in your areas is the Special Needs Planning Academy. And like the National Association of Elder Law Attorneys, you can put in your zip code there and you can find planners in your area as well. So having said that, Rachel, we are so happy that you are back with us today. We're going to be talking about the top 10 questions about special needs trust, and I know that we've got some other sprinkled things in there, added benefits and kind of public benefits and stuff like that. But I'm going to turn everything over to you, and I'll pipe back in with some questions in a bit.
Wonderful. Thank you so much. So, what I like to start with any questions is start with government benefits. So, on the next slide, I have some more information about the most common government benefits. Everything starts there. So, the most common government benefits that you will see is Supplemental Security Income, or SSI. This year, that is $967 per month for food and shelter. Also, along with that, you have Medicaid, which will give some healthcare coverage. There also may be Medicaid waivers. So these vary from state to state. They're all a little bit different. In Texas, you can have Medicaid waiver programs that have attendant care, that have respite, different therapy options, residential options, and supplies. They all have a little bit of detailed information depending on which program you're in. But let's talk about SSI and Medicaid a little bit more.
Rachel, I just wanted to mention on the Medicaid waivers, I want to say that we have a webinar completely dedicated to Medicaid waivers in Texas, how to get on the Medicaid waiver interest list, what are the Medicaid waivers in Texas, how do they work, what do they pay for, that kind of thing. So you guys can check that out on the YouTube channel. Unfortunately, in Texas, the Medicaid waivers have a very long waiting list, and they're saying in excess of 20 years at this point. So it's very important that you get yourself on this list. If you're not already, you can check where you are on the list at Health and Human Services, yourtexasbenefits.com. You can see where you are in the interest list nowadays. Other states, all states have Medicaid waivers. So if you're attending from out of state, just know that your state has Medicaid waivers too. And Medicaid waivers are really designed to waive off some of the cost of care for caring for an individual with a disability to keep them in home and community-based services. Some states don't have any waiting list at all. So you're going to want to check with your state on that as well.
Yeah, and if you take just one action today, I would recommend that you get your child on the waiting list, especially if they're young, because with that 20-year wait list, that might be whenever they need services later on. So that's one action I would strongly recommend you take today if you're not going to do anything else.
I would also like to say that it feels discouraging for Texans that, when they look at the list and their kid is like 150,000 on the list or something, it feels pretty discouraging. But other states have been in similar situations as us with very, very long waiting lists. And then they passed a law or they charged a new tax and then they got everybody off of the waiting list. So some people might say, well, why put them on the list? I mean, it's going to be 20 years. Who even cares? How would I know the difference? And the thing is it can change. It can change, and it has changed for many unlikely states. I still remain hopeful and optimistic that that might change in the future.
All right, so for SSI and Medicaid, there is three main requirements. The first one is a disability determination from the Social Security Administration. And then you also have to have low income and limited resources. For the waiver programs, again, I'm going to refer you back to the webinar that Allison mentioned. All of them have their own different requirements, and some of them have different ways that you can get on the list. So I'm going to refer you back to that webinar. It's going to have a lot of great information for you. Let's talk about low income and limited resources and what that actually means. So on the next slide, I have some information about income. So for SSI, you have to be making less than $1,620 this year for SSI. That amount does change every single year. Generally, it's around $2,000. You can only have $2,000 in your bank account, but that's how much is going in, is coming to you, to your child with disabilities, how much they're making. For Medicaid, it's less than $2,000. How they define income is shelter, cash, and any assets that can be converted to shelter. So this tends to be rental costs, it tends to be housing, anything that is provided, and it can be whenever you provide it for them. I'm going to talk about that a little bit more in the next slide. But whenever your child is under the age of 18, any income that you make is going to be deemed to your child. So most of the time, around age 18 is when we start applying for SSI and Medicaid, because parents will make too much and they won't be able to qualify for SSI for their child. Now, in Texas, if you receive $1 of SSI, you will also have Medicaid eligibility. So you will automatically have that eligibility if you're on the SSI program. Let's go to the next slide. So for income, in-kind support and maintenance is considered to be income. This is when someone else provides shelter to the child with disabilities. It used to be that it was food and shelter. That rule did change in a later September of last year. So you're going to see a lot of resources that say food and shelter. It is now when just someone provides shelter. So if you are providing rental costs, if you're paying for your child's mortgage, they're living underneath your roof, then that's considered to be in-kind support and maintenance. What happens is there's a 1/3 automatic reduction from their SSI payment. So it goes from $967 to approximately $600. Now, there are strategies so that you can increase your SSI payment. It's the full amount. You have to pay rent. So you have to have the individual actually paying rent to you. They can pay for their pro rata share of whatever those costs are. or you can run it through an ABLE account. And we're going to be talking about ABLE accounts a little bit later, but they do allow you to have expenses paid out for rent and not impact government benefits. So this is something that it can trip up a lot of parents. We want you to be aware of that. And there's some strategies that you can use to have this one-third reduction not happen. Next
Um,
slide. Oh,
we
yes.
have a question. It says one question I have today is our DAC was on, and that stands for Disabled Adult Child, and that's the term that they used for 40 years, and now they changed that to CDB, Childhood Disability Benefits. They were getting SSI and Medicaid for 18 years, but now at age 40, she qualified and is approved to receive Social Security off of my record, also SSDI or CDB, and it is over the amount of SSI, and Medicaid and SSI has been closed. Does the Special Needs Trust still have the same applications and distribution requirements? But one thing I want to be clear on, because this is a real issue in Texas, of when they switch over from SSI to the childhood disability benefits, the benefits that you're speaking of, the SSI Medicaid goes away, but they are a mandatory Medicaid group. And unfortunately, because there is a lot of kind of moving parts and confusion at Health and Human Services as well as the Social Security Administration, oftentimes you're going to have to reapply for Medicaid. It's the H1200 application. And on the top of that, you should write DAC Medicaid, mandatory Medicaid group. You should send a cover letter saying that the Medicaid was canceled when they switched from SSI to childhood disability benefits under a parent's record, and it needs to be reinstated. And unfortunately, a lot of families don't know to do that, but they are a mandatory Medicaid group. They do get to keep Medicaid. You often do have to reapply in Texas. It doesn't always work that way in other states. And after 24 months of being on benefits under a parent's record, your child is going, once they're over 18 and 24 months has passed, they're going to be eligible for Medicare, which will make them dual eligible. So if that resonates with you, reach out, we can help you further. But that is a conundrum that is happening in Texas on a regular basis. And people don't know that they have to reapply. And some people have reapplied and their applications went to the abyss and they're frustrated. But there is help out there for you. So I wanted to mention that. But let's answer his question about does the Special Needs Trust still have the same applications, distribution requirements, government benefits, etc.
Well, it is a little bit different. It depends on if you are still on that Medicaid waiver program, or it's not waiver program. If you're still receiving Medicaid, then you still need that special needs trust. If you decide that maybe you don't want to be on Medicaid, I'm not sure. It's helpful to have both, but you could decide that you don't need that special needs trust. I would still recommend having it in place because you don't know what's going to happen with Medicaid and what programs and eligibility you might be able to get with Medicaid waiver programs later down the line. So I still recommend a special needs trust even in that situation.
I agree with you as well. And I would also say that, with the Special Needs Trust, that is also going to protect the individual with disabilities from what we call bad actors, people trying to take advantage of them when you're gone. So there's benefits that way. And one thing that people say all the time, Rachel, is that you cannot pay for shelter out of a special needs trust, and it's simply not true. You can pay for shelter out of a special needs trust, but as she was talking, there would be a one-third reduction to SSI, but that is not true for childhood disability benefits under a parent's record. The rules change. So I think it's valuable to keep that. So here's a question that says, are there any restrictions on spending from a special needs trust if the recipient is on a Medicaid waiver, for instance, HCS, so long as the spending is for the benefit of the recipient to improve their quality of life? And is this where you would say, Rachel, we don't ever want to make a distribution directly to the individual, but on their behalf? Is that right?
That's correct. So we want to be careful. I would say talk to your attorney about your specific Medicaid waiver program because each one has different requirements. So just make sure everything's solid and good to go. But yes, you don't want to have any distributions directly to that individual.
Perfect. Okay, we're going to move on for now and we'll come back to some questions.
Wonderful. All right, so we have the disability requirement, we have the income requirement, there's also a resource requirement. So you also have to have less than $2,000 in countable resources. What is not counted is a home, a car, personal items, and 529 education accounts. What is counted is bank accounts, uniform transfer to minor accounts if they're after age 21, investments, and real estate. What is also not counted is a special needs trust. And that's one of the benefits. Any money or inheritance that's left to that special needs trust, it's not going to count towards those resources.
We don't see UTMA and UGMA accounts very often anymore, but we do see them a few times a year. Most people have moved over to the 529 plans as opposed to the UTMA or the UGMA accounts, but those can be problematic, and I'm really glad you brought that up.
All right, so we were talking about disabled adult child, just to give you a little bit of background on what that program looks like and how you can become eligible. So if the child was disabled prior to age 22 and they have a disability determination from Social Security, once a parent passes away or they start taking their Social Security retirement, they may be eligible for half of the parent's Social Security check. And then after 2 years, they may be eligible for Medicare. And as Allison was mentioning, you can get Medicaid and Medicare, and we would recommend that you do that so you have the maximum amount of government benefits for your child. All right. So on Medicaid waiver programs, again, I would recommend that you watch the other presentation on all of these programs. The important thing to note is there is a lot of different programs out there. I recommend that you look into it, see what would work for your child. And for the big waiver programs, get your child on the list as soon as possible. From what I've heard, the most recent one I heard from the state was 17 years, but from parents, I'm hearing around 20 years or more. So I want you to know that you should get your child on the list as soon as possible. Next slide, please. All right. The programs that are not needs-based are SSI, or excuse me, SSDI and Medicare. So these have different requirements than the less than $2,000 resource requirement. They work and interact differently with special needs trusts. I just don't have time to cover all of that today. All right, next slide, please. All right. So what makes a special needs trust so special is it is not accountable resources. So most of the time, government benefits are insufficient to take care of your child with disabilities. $967 per month, it's not enough. And you need other money that can be used for your child's care. But we want to still have the government benefits so you're maximizing any money that is going to your child so that they have the best future and outlook for them. So what we do is we put that money into a special needs trust. We want to make sure that they're not losing their government benefits because it's not over that resource requirement, and it can supplement anything the government benefits provide for. Next slide, please. All right, so a special needs trust, it's not a countable resource. You have to have some specific provisions in that special needs trust to make sure it's going to qualify. But what happens is the assets that are in the special needs trust, they're going to supplement government benefits, which means that generally anything that is in the special needs trust, we use the government benefits first, and then we use the assets that are in the special needs trust. The distributions coming out of the trust are also not income to the child if they're done done correctly, and then they will not disqualify your child on that basis either. Right. Next slide, please. All right. Now, you may be thinking, do I truly need government benefits for my child? Maybe they're higher functioning and you're not sure if they're going to be eligible or not. I still recommend you have a special needs trust for your child. If they are not on government benefits, it operates as a regular trust, meaning distributions can be made for their health, education, maintenance, and support. The only difference is that your child will not be able to be the trustee of their own trust. This also helps them for bad actor protection. Like Allison was mentioning, we want to make sure that you're protecting this money for the long haul for your child. There's no issues with that. So the trust will manage all the assets and distributions for that child. And it really has flexibility for changed circumstances depending on what government benefits they're on, or even if they're not on government benefits.
Rachel, we see sometimes people that have a will and they may call it a pour over special needs trust or a
Mhm.
testamentary trust. Basically, what that means is that the special needs trust will be created, for instance, upon my death. So it's not a standalone trust yet. It's not funded, but it will be created upon my death. Um, and that is one way to go about doing it. I am a fan of having a standalone special needs trust. And the reasons I have of having a standalone trust is number one, if you have a pour over trust, if your parents die and want to leave money to your special needs child, that doesn't create the trust, right? Because you're still living. That's one issue. So if there's any people that might, leave an inheritance for the benefit of your child, that's one reason. The other reason I feel like it's important to have the special needs trust already established because at death, that's an event. That's a big deal. It's a big deal for your child with disabilities. Things take time. Death certificates take time. Claims, death claims, life insurance claims, all that kind of stuff takes time. Legal documents and creating things takes time. And you could lose 3 to 4 months there. And in the meantime, your child with a disability has care needs. And so I just wanted to mention that because I see that come up a lot. Do you have any thoughts on that, Rachel?
I completely agree. I talk to my clients about this. Most of my clients want to do a standalone special needs trust document. The other benefit of that is you get to lay out the specific terms of what you want to have with your child in more depth than we typically do for a will. And so it's beneficial to have that standalone document. I have done what you mentioned, a pour over S&T. I've done it in the will before, but most of my clients do a standalone because of the benefits it offers them.
And what I would say is on the pour over, it is a cheaper way. So if a person is saying, I can't afford to get a special needs trust right now, it's a cheaper way to solve a problem. If you are an individual and you don't have lots and lots of assets or savings, and there's no chance that anybody in your family is ever going to leave anything to anybody, that may be a good start. So don't be discouraged. We're not saying that's a terrible thing to do. It is one way to go about doing it, but we prefer the standalone as opposed to going that way. But there are reasons where that may be more appropriate, and a qualified attorney like Rachel would talk through those options with you so you can make an informed decision.
All right, so there are two major types of a special needs trust. The one that you probably have heard of is a third party special needs trust. Whenever someone's telling you you need to get a special needs trust as part of your estate planning, that's what they're talking about. But let's talk about the two differences. So, a first party special needs trust is created with the individual with disabilities' own money. So, this can be from inheritance. This type of inheritance is when they get something outright. So, there is a mislabeling of a beneficiary designation, or there is something in the will that leaves it to their individual name and not to a special needs trust. If they're getting child supports, that's lifetime child support for them, or when it's that individual's own savings and money that they want to put in the trust. The thing with a first party special needs trust is there is a Medicaid payback provision. So, any money that is used for your child by Texas Medicaid or any state Medicaid program, they're going to keep a documentation list of every dollar that they've spent. Whenever that child passes away, then they're going to have to pay all of that back before it goes to your other children or any other individuals. So that's called a Medicaid payback provision. That's primarily just for a first party special needs trust.
And I just wanted to mention, because sometimes we have people from out of state, not all states have a Medicaid payback on their first party special needs trust. So then begs the question, well, let's say such and such state doesn't have a Medicaid payback. Can I just go get my first party special needs trust there? And the answer is no. If you live in Texas, the rules for that state that you reside in apply, and that's true for able accounts as well, because we have had that come up. But just be clear that there's definitely not always a Medicaid payback, and there's been some proposed legislation that they're going to get rid of this. It has never passed. I hear people say, I heard that pass. We hope it does, but it hasn't passed yet, but maybe one day it will. So that is an important thing. because we're on that first party special needs trust, you had a big one on the child support. So the
Yes.
crazy thing about social security SSI is child support is going to be, counted against them for SSI purposes if it's not going or redirected to a first party special needs trust. A lot of states, including Texas, have child support that continues on post age 18, sometimes for the life of the individual with a disability. So you're going to want to work with your attorney to get that redirected to a first party special needs trust. And unfortunately, you might need two attorneys because an attorney like Rachel, she's going to set up the first party special needs trust, but she's not a child support attorney or a divorce attorney, right? So you need that child support attorney that's going to work with the judge to get it redirected to that first party special needs trust. So it's very, very important, and people can get denied for SSI because that is not worked out.
Yeah, and while we're on that topic, the requirement of child support in the divorce decree, it must state that it goes to a first party special needs trust. So if it is not in your current divorce decree, they're going to have child support after 18. We actually have to go in and do a modification on that child support. It's not ideal, but it is helpful for your child. And overall, it's going to be worth it for you.
And to that point, Rachel, because it does have to be a court order, that's important to note because people think, well, I'll work with somebody like Rachel and I'll get a first party special needs trust, and then I'll go to the bank and I'll set up a first party special needs trust account, and then I'll just redirect it to that. And that's wrong. You can't, I mean, you could do it, but it's wrong, and you'll have to unravel that, is basically what you're saying.
Yes. All right. I think we went backwards instead of forward. So we can go forward one or two slides. All right. Third party special needs trusts. So this is created with someone else's own money. The wonderful news about a third party special needs trust is there is no Medicaid payback. So the most common way that this is done is in your will, or if the standalone special needs trust, you're leaving money to your child whenever you pass away. If you do this, then there will be no Medicaid payback. And whenever your child passes away, then it can go to other beneficiaries, your other children, your disabled child, if they have any children, it can go through any of those methods. You can also use this for grandparents leaving money to the trust. So this is the ideal form. This is probably what you hear of when you hear someone say, I have a special needs trust.
Can we talk about 401ks? Like a lot of times a 401k is qualified money, okay? It's qualified money. And a lot of times people in their assets, they have more qualified money than they have non-qualified money. And oftentimes people might leave an IRA or a 401k to a special needs trust. Can you talk about like the lifetime stretch? And there was a lot of upheaval in that community for a long time because there was a law a few years ago with the Secure Act or whatever, and it was kind of clear as mud. And then they clarified it, and then there's a such thing as a lifetime stretch. So can you talk about that?
Of course. So with 401ks and IRAs, you have to have certain language in your special needs trust for this to qualify. So if you have a trust that's pre 2017, 2020, it probably doesn't have this language. I would strongly recommend that you go and talk to an attorney to get this language in your trust. But whenever you leave distributions to your child with special needs, say that there's a child with special needs and then a neurotypical child. If it goes to the neurotypical child, those assets that are in the 401k, they have to take them out over a 10-year period. They have to take it out. They don't get a choice on that. They also have to pay taxes at their income tax rate. For a special needs beneficiary, they get to take it out over their lifetime. So say the IRS single life chart says that it's 40-year period. They do it over 1/40th of each year. So they're taking out a smaller amount. What this means is that there's more growth over time. And often your child with disabilities, they're in a lower tax brackets. They pay less in taxes. I have a lot of clients that will leave their 401ks to their special needs child and then will leave life insurance or some other asset to their neurotypical child because there's more tax advantage for that.
Because life insurance passes tax free to heirs.
Yes.
So that is definitely a fact. That's a great question, and we can go deeper at a later time on that. But there has been a lot of confusion on that for sure. Um, the other thing on the lifetime stretch, it's important to know, and it's important for your beneficiaries to know that there are requirements to. It's not just in the legal document, like, but notification of the company prior. It's like prior to October following the year of death, proof of certification that they qualify for the lifetime stretch. There's some other little nuances and rules that you want to make yourself aware of. I just want to put that out there.
All right. So we have the special needs trust created. So you go to an attorney, you have all the special needs trust, it's created. How do we actually get that money into the special needs trust? What is the typical way that all of that goes? So a lot of people will put in their will whatever portion is going to my special needs child, it's going them to them directly into their special needs trust. You do not want to have it go to them outright because then it would have to go into a first party trust. So you want to name their third party trust in that will. You can also name the special needs trust as a beneficiary for life insurance and for retirement accounts. So that's a great way to get that to your child, especially if you're worried about getting all of that to them immediately. That's the fastest thing you can do. It's faster than going through probate. So that's a potential option for you. You can also fund the trust through gifts from other individuals or through child support. So there's a lot of different ways that you need to get it to the trust, but just creating the trust is not enough. You have to actually make sure that everything is pointed to the trust so you're actually funding the trust.
And I would just like to add that it's important to have intentional conversations with any aging family members that might potentially want to leave money to their favorite little grandson or granddaughter or whatever. Because as I mentioned earlier, how few professionals are nuanced and special needs, it accidentally happens quickly. Grandma and grandpa go to their financial advisor and they say, we have this grandson and he's on the spectrum and we really want to help for his future care. And the advisor says, great, what's his name? And they name him directly as a beneficiary as opposed to the special needs trust for the benefit of little Johnny. So when you get your special needs trust set up, your third party special needs trust, it is important to notify your aging parents or other people that might potentially want to do something. The thing is, a lot of our aging family members, they keep their cards close to their chest. They don't always talk about money or inheritance or what I plan to leave, and sometimes they're secretive about it. And we, suggest opening the door. I've recently done some planning. I've recently got my legal documents in place. We're learning about public benefits and what little Johnny may qualify for and how he would accidentally disqualify. And we learned the following. And as a result, we set up a special needs trust. And we were advised by our legal team to let our family know that if anybody ever plans, we're assuming nothing, but if anybody ever plans to leave money to little Johnny, we need to leave it to the third party special needs trust for his benefit. And then you give them the name of it. And they are appreciative of that, but their financial advisor does not know that. So it's going to be up to you to have that communication with your family, and it's really important.
Definitely. All right, so we're going to take all of those different types of assets that I mentioned. All of it's going to be funneled into the special needs trust and can be used for your child's benefit. Let's go to the next slide. I know we talked about child support a little bit already. The only other thing I'll mention is if you are considering getting divorced, there's a divorce filing that's been done. Go and talk to a special needs planner that has experience in child support because you want to make sure it's set up correctly from the beginning. The best time to get all of this stuff set up, even if your child's not close to 18, is whenever you're first going through the divorce, whenever people are already negotiating everything. We don't want to come back 10 years from now and then try and negotiate everything. It's better to get it done correctly the first time.
And much cheaper to get it done correctly the first time. And what I would say to whether there's moms or dads on here, people who have custody, people that don't have custody, at the end of the day, it's for the best interest of the child. So you might be angry at the other spouse, but this is really for the best interest of the child. And so anybody digging their heels on not having the child support redirected to the special needs trust. It's not helping the child because, again, we want to maintain their eligibility for state and federally funded programs, for SSI, for Medicaid, and then essentially for disabled adult child benefits under a parent's record. So one person asked, is it better to have a special needs trust before we contact a family lawyer to modify the child support, or the other way around?
It's gonna be the other way around. So, for child support specifically, we have to have that in the divorce decree that a special needs trust is gonna be created, but Social Security actually likes that the special needs trust is signed after the divorce decree is signed. So we get everything prepped, we're ready to go, we modify the language in the divorce decree, but we don't actually sign anything until after the divorce decree is signed.
So there were some other questions, and there was just a comment in the chat box. And the first thing I want to say is take a deep breath. It is never too late. Okay. You're not behind. You are where you are. It is never too late. I don't care if your kid is 26 and they're not getting SSI yet because you didn't know you should apply. I don't care if they're 44 and you don't have a special needs trust. It's not too late. You're not too late to the party, and it can be fixed. And there are plenty of times where people want their child support modified. Maybe the payer wants it lowered. Maybe the caregiver wants it increased because of the care needs of the child. And there are such things as child support modification. That's a different law firm. That's not the Weeks law firm, but there are specific attorneys, and we do know of them across the state, that they are specific for child support cases, divorce cases, but they are also specifically nuanced and special needs, and they know what language needs to be in your documents. So all I want to say is don't be discouraged. Don't beat yourself up. It's not too late. And there's always corrective actions or changes that can happen that can change your situation, and you didn't screw this up. That's why we do this. Okay. So I just wanted to say that it's important.
Definitely. And I will mention, even if something happens to you, I don't want you to worry about that because there are ways we can fix it. It's just not going to be as ideal for your child, but we're going to do everything possible, even after the fact, maybe after you pass away, to make sure that we can help. It just might not be ideal. It might have to go into a first party and there's Medicaid payback. We can still make sure that your child can be eligible for benefits.
So I call that an oops trust. So oops, somebody left money directly to my kid as opposed to the third party special needs trust. All is not lost. You might lose benefits for a month or two, but you can set up a first party special needs trust and have that money redirected to the first party special needs trust. And the downfall to that is there is a Medicaid payback in that special needs trust. So it's not the end of the world. If you can prevent it, it's good. But if something accidentally happens, then there are fixes for it. It just may come with a Medicaid payback.
All right, so for trust funds, we have everything funded in the trust. What can the trust funds actually be used for? So Social Security does not like distributions to be cash or debit cards, and it can't be anything that's paid for by government benefits. Now that sounds like a lot of different things. What can you use it for? Next slide, please. So you can use it for personal items, for social and recreational activities, entertainment, education, and medical expenses that are not provided for by government benefits. I promise you there is something that your child needs that you can use a special needs trust for. We think of new things every day that your special needs trust can be used for. It's just something that Medicaid or Medicare does not cover. That's what this would be. And even if you have shelter costs, if that needs to come out of the trust, you can still use that trust for shelter costs. Depending on the trust language, sometimes it will be a little bit more restrictive, but you can still use it for that, even if it reduces the government benefits, if it's in the ideal situation for that child. Next slide, please. So how expenses are paid out of the trust, you need to either pay expenses directly to the third party. Most of the time, this is done via check. So say that they are in a day hab program, if there's some a fee associated with it, the trustee can pay for that directly with a check. They can also have a credit card that's linked to the trust. The trustee pays off each month. Or there can be a TrueLink credit card. A TrueLink credit card is basically a prepaid credit card, and you can actually put an allowance and you can put restrictions on that card. It's a great resource if your child is higher functioning and maybe they go out, they use money for different expenses. You can have an allowance go to that card, but still monitor the expenses, making sure that they're still going to qualify for government benefits.
So can you have a both a first party and a third party trust? And what happens if you accidentally commingle the funds between the two? Is there any way to fix that? For instance, a parent accidentally leaves money to a first party trust. Can they move it to the third party trust, or is that even allowed?
That's a great question. So yes, you can have a first party and a third party. I You have to be careful about this because once it goes into a first party trust, it's considered to be that child's own income. You can't transfer it to the third party trust. So I would you can't fix that once it goes to the first party trust. It just needs to stay in that trust. It's going to be now eligible for Medicaid payback, and as far as I'm aware, there's not a way to fix that. It just needs to stay the way it is.
But I also just wanted to mention that there could be an unlimited amount of first party and third party trust. Grandma and grandpa could have set one up themselves.
Mhm.
In divorce situations, mom could set one up and dad could set one up because they don't want the other person to be the trustee. I've seen divorce situations where they come together and they have one first party and one third party or whatever, but there is not a limit. And sometimes people get confused on that because a person with a disability can only have one able account, but there's an unlimited amount of special needs trust that that individual could have, because remember, they are not the trustee on any of these.
All right. So the next slide, we're going to talk about the trustee duties. So what the trustee is going to do, they're going to invest the assets that are in that trust. They have to understand how distributions from the trust affect government benefits. They have to distribute for their care, keep detailed financial records, and file a tax return. But a lot of people have not done this before. They may not have been able to do any of these things. So, what do you look for? So, on the next slide, we have some characteristics of things that we consider the trustee to need to do that would make a good trustee. So, they need to be reliable. They need to be have a lot of integrity. They need to be able to learn and implement the special needs trust rules. Most of the time, it is a family member or a friend. However, if you don't have that individual in your life that you trust, or you don't want to put that on your child or with your family members, you can seek professional assistance. So there are corporate trustee options out there. They do charge a percentage of the assets. There's also something called the ARC Pool Trust with ARC of Texas. If you're in Texas, that does allow for funds to be left to a special needs trust with ARC, but they only accept cash assets, or they have to be converted to cash in order to go into it. So there are some restrictions. I would talk to your attorney about if that might be a good option for you.
There are pooled trusts all across the United States, not just in Texas. There are definitely pooled trusts everywhere. With our families, we see more standalone, not involved in the pooled trust. Sometimes settlements. Sometimes if there was a lawsuit or a medical malpractice or something like that, there might, the assets may go into the pooled trust. And we're not against the pooled trust. I would just say that we see more of the standalone trust as opposed to the pooled trust. But there's a lot of them out there, so you would want to research those carefully. Because one person did say, um, "Is there a schematic or different pooled special needs trust in Texas which compares benefits, cost, and fees?"
As far as I went, I don't have a schematic on all of those different fees, and what they would be depending on. It really just depends on what's in your trust or what's in ARC of Texas. They have their own fee structure.
And then one person said, "Should I be funding this special needs trust now, or is it mostly used to funnel funds in the event of death?" Rachel, I'm a fan of leaving their assets nimble for the 25 to 35 years that they may be in retirement. They may be funding weddings or college for other kids and things like that. And I think that answer depends. It depends on how much money there is. If there's plenty of money, we've got plenty of money to retire and stay retired and pay for weddings and college and all that other stuff, and we can fund as well. Otherwise, we would say fund it at your death with either life insurance or the remaining assets or a combination of the two. Do you have any thoughts on that?
I completely agree. I like to keep things most of my clients will have it that they wait until their death or the death of a family member to fund a trust. But I do have some clients that decide that they want to start setting aside money now and it's specifically used for that child. So it just depends on your circumstances. For most families, you want to wait until your death and keep that options. We also, these trusts are revocable, amendable, so you can change them along the time that you're still alive. And then any changes that you need, maybe the trustee that you really trusted 20 years ago, it's not the right person anymore. You can amend that, change it before you fund it. So I tend to recommend wait until you pass away, but other attorneys have different ideas about that.
Sure,
Okay.
thank you.
All right. So what else do you need? So I would recommend that you do all of your estate planning documents. I recommend this for everyone. This is really important for special needs families because you don't know when something's going to happen to you. So you want to make sure you're coordinating everything, not just a special needs trust, but how that money gets into the trust and look at your beneficiary designations, making sure all of that's set up. And we talked a little bit about coordinating with other family members. Just know that a special needs trust alone is not enough. We need to have everything in place. All right. Now, I know we're running a little low on time, so I'm going to go a little quick through these next couple slides, but ABLE accounts. ABLE accounts, they have a Medicaid payback provision. That's one downside with these, but you can keep up to $100,000 in these accounts without impacting government benefits. You can contribute, it says $18,000 per year. It should be $19,000 this year into that account without affecting government benefits. In order to have this type of account, you have to be disabled or blind before age 26. Next year, that age is increasing to age 46. Next slide, please.
I just wanted to mention it doesn't necessarily mean that they have to be getting SSI or SSDI. Some people are disabled and they're not getting those benefits as long as you have proof of disability. I've actually never opened an ABLE account and had them ask for proof. I guess they could, but I just wanted to mention that because some people feel like if they're not getting SSI or SSDI, that they can't have an ABLE account. And I also wanted to mention 19,000 for 2025. If the individual with the disability is working, they can contribute an additional 15,560 for 2025 up to their earnings amount. So if they worked and they only earned 5,000, they could contribute an additional 5,000 above and beyond that 19,000. And that number changes every year and it's subject to the gift tax exclusion. So it's every single year it's going to change a little bit. It usually goes up by about 1,000.
Yes. And for this account, if you have $100,000 in it, you're receiving SSI, you will still be exempt at that point. But once you go over $100,000, you will not have SSI, but you can retain Medicaid eligibility. Now, this is specifically for Texas. Every program is a little bit different. There's one in every single state. But for Texas, the state limit and the amount of in that account is 500,000. But that's only for Medicaid. So when should you use those accounts? So on the next slide, I talk a little bit about that. Oh, excuse me. I jumped ahead a little bit. So allowable expenses, you can use it for education, housing and transportation, health and wellness, assistive technology, and legal fees. There's a broad range of different things that you can use this for. Some people also like to have this as a backup savings account for that child with disabilities.
I think one of the key things, because people say, why should I have an ABLE account in a special needs trust? An ABLE account can pay for shelter without a 1/3 reduction to SSI. So what we said earlier is a special needs trust can pay for shelter, but there would be a 1/3 reduction to SSI. An ABLE account can pay for shelter without a 1/3 reduction to SSI. So that's one reason. And what's important, the chicken or the egg, ABLE or special needs trust first. I think that they're both equally important. And one thing that to remember about an ABLE account is that $100,000. And you can't make a beneficiary an ABLE account. So while you can make a beneficiary a special needs trust for the benefit of said child, you can't do that with an ABLE account. And an ABLE account has a limited amount of money that can go in each year. So it's it's really cheap to open up an Able account. You don't have to have 19,000 to open it up. You can open an Able account with $100. We help people with that. We have entire webinars on the Able account on our YouTube channel, so you'll want to check that out. We definitely help people open Able accounts all the time. And one question that comes up from time to time is, if my child isn't getting public benefits or Medicaid, do I need an Able account? And I would lean towards no, because there is a Medicaid payback on that. So if they're not getting public benefits, they're not getting Medicaid, I would wait until they are to open an Able account, is my opinion. You can always get an Able account later, but don't put something that has a Medicaid payback in it if there's no reason to, because there's a lot of other types of accounts that we could do that wouldn't have a Medicaid payback if it doesn't matter.
I agree. All right, on the next slide, so the interest is not income to the beneficiary and distributions are not income, so it doesn't impact government benefits, is the big summary from this. You may be asked to provide records to the Social Security Administration, so just keep that in the back of your mind. On the next slide, I talk about the major drawbacks with these types of accounts. The biggest drawback is there is the Medicaid payback provision. So just something to keep in mind, it is helpful in a lot of different circumstances. If we go over to the next slide, this is when I recommend that you use them. And I think, and it should be the slide before this, I think. So I recommend that you use the ABLE account whenever the individual is earning their or saving their own earnings. So if they are working, it's a great use of keeping all of that while keeping all of their earnings while still being eligible for government benefits. If you have a small gift or inheritance that's less than that $19,000 amount, you may not need to do a first party trust. There's still going to be Medicaid payback if it's going to the ABLE account, but this is a great option. And then also, you can roll over a 529 account to an ABLE account if it's the same beneficiary. So I see a lot of people using this and taking advantage of those funds. You can also use it to pay rent. So a lot of my families will have a special needs trust and ABLE account, and they'll transfer funds from the S&T to the ABLE and then use that to pay for the rent.
We help people roll from the 529C to the ABLE, and I am a fan of that, especially if you don't think or you don't know if the child is going to go to higher education, because the ABLE account is very unrestrictive, whereas the 529C is pretty restrictive of where the money goes and what the money can be used for. But the ABLE account can pay for higher education as well. So converting that might be smart, but just know you can't convert it all at once. So if you have $100,000 in a 529C, you can't just change it over to a 529 ABLE. It has to go at that rate of that $19,000 a year. So that is important.
So I know we're running short on time. I want to get another couple questions in if we have them. The last couple slides that I have are really just talking about when do I need to create a special needs trust and what's the ultimate result of that special needs trust. So I say before you become disabled yourself or you have a disability, that's the kind of whenever we can't do the special needs trust anymore. It's not related to guardianship and it's never too late to create that special needs trust. And then what's the result of having wise planning? Really, that's looking at having a solid financial plan for your child, making sure you have instructions for their care, and ultimately providing it for more well-being for them. And part of that is from our side, and part of that's from the financial planning side. So really having all of that structure all together.
We did have a lot of questions today that came in about guardianship and alternatives to guardianship. In Texas, it's the least restrictive, most appropriate for the ward, is the way the person, the human. Um, and that is a whole webinar in itself. We've done many webinars on guardianship and alternatives to guardianship. Some states have something called supported decision making agreements. There's power of attorney, healthcare power of attorney. There's partial guardianship. A full guardianship is going to take all of the rights away, the right to drive, the right to vote, etc. There are such things as partial guardianship. Every state is different. In fact, one person said, if I got guardianship in Ohio but now live in Texas, you need to talk to a Texas attorney and you need to get your guardianship moved to Texas. And the truth is if I live in Fort Bend County and I move to Harris County and I have guardianship, I got to get it fixed. Okay. That may not be true in your state. If you're in, Virginia, if you're in Florida, California, they have different laws. Some states call it conservatorship. Some states use different words. But what I like to tell people is don't feel nervous about guardianship. The attorneys are trained to talk to you, to talk to the child, and to guide you what is the least restrictive and most appropriate for the individual. I think a litmus test is if a person has an intellectual disability, they are incapacitated. They don't have the ability to understand a contract or enter into a contract. They could be easily hoodooed or taken advantage of because of their intellectual disability. That may be a good reason that you need to consider more restrictive than the supported decision making agreement, such as a partial guardianship or guardianship. But you don't have to know everything. You don't have to be nervous about it. The attorney's gonna walk you through every single one of your options. And sometimes people start, like I started least restrictive, and I never had to up the ante. It was questionable for one of the kids, but I never, so we started least restrictive and we never had to up the ante. You're not too late. So guardianship starts at age 18, right? You can start that process 6 months before they turn 18. But if they're 26 and you're just hearing this for the first time, again, it's not too late. You can have those conversations. What I worry about on the least restrictive, most appropriate is sometimes it's leaning to that supported decision-making agreement or power of attorney and healthcare power of attorney. And I've seen families that have done this when the person did not have capacity. And that can be just as disastrous. So it's really important to make good choices on that and seek professionals that really know what they're doing with that. And again, check out those webinars on the YouTube channel about these. We've talked about a lot of stuff. We are out of time for today. And I just want to say that you guys are going to get a copy of all of these slides with a link to our upcoming webinars. We offer free personalized consultations. So if you've got questions that didn't get answered today, we're happy to talk to you a little bit further. This QR code on the screen will take you to our calendar, which you can schedule your free personalized consultation. Rachel, as always, you were fantastic. Lots of great information. Guys, feel empowered, feel encouraged. You've got this. I know it does feel overwhelming, but we're here to help. There's a lot of help out there, and it doesn't matter what state you are in. When it comes to your legal documents and your special needs trust and your guardianship, you are going to want to work with a professional, an attorney in your state. We work with people all across the United States. Thank you for your questions today. It's certainly been a pleasure to be here with you, and thank you again, Rachel, for all of your great advice here. Have a good afternoon, everyone.